Committee will please come to order. I'll ask our clerk to take a silent roll call to determine presence of a quorum. And we have quorum. When we recessed last night, we had under consideration House Bill 4145, and under consideration under that, a strike and insert amendment, and under consideration within that, the pending question was an amendment offered by the senator from Upshur County that would require, in the section dealing with school facilities, it's section 11A of Article 7, would require language that required posting a notice when private educational schools or facilities had adopted written policies to preclude firearms on the premises. I believe that's where we were. Are there members who desire further to speak to that amendment? Senator from the 2nd.
Thank you, Mr. Chairman, and I think you got that right on the nose there with where we left off, because in my thoughts of where we left off last night, I was about ready to push the button and talk.
It seems as if we were just here.
It's just as if we were just here, yes, sir. And I agree with the senator from Upshur's motion, and I know there's a little bit of confusion there with fixed sites and not sites, but if we can remember from the debate on charter schools last year, my granddaughter went to a charter school out in California, and when that school was starting up, they didn't know 1 week to the next what building that they were going to be in. It might be a town hall one day, it might be a church rectory the next week, it might be somebody's home. It didn't affect the quality of the education she received, but quite frankly, they didn't know what was going to be considered a school at that time. And as we get into this realm of charter schools potentially here in the state of West Virginia and more homeschooling, we're going to see this situation crop up. And I think the gentleman's amendment helps clear that to make sure that we don't have anybody getting into trouble for no reason. Much similar to for the same concept of the amendment that I offered earlier that was adopted by this committee. So I speak in favor of the amendment.
Are there other members who desire to speak to the amendment offered by the senator from Upshur? Senator from Harrison County.
Thank you, Mr. Chairman. If you're thinking about this overnight, and overnight always gives you a little clarity, I see the utility in the amendment. However, my concern is that, every private school, every Notre Dame, every St. Francis, every, Heritage Christian school is going to have one of those signs at every entrance. Because if you come into an entrance without the sign, there legitimately could be the argument that you weren't informed that this was a school. I would offer an amendment to the amendment that simply adds to the senator from Upshur's amendment if the location is not clearly marked through signage or usage as a private school. That way, we take care of when the senator from Mullins' granddaughter is going from building to building trying to find a location, but we don't make someone like St. Francis put a sign at every entrance when it's clearly a school. And that would seem to be a common sense amendment that would take care of everybody's concerns and at the same time recognize that we know where 99.5% of the schools are because they've been there forever, and it seems unnecessary to put the private schools through the cost and the concern of marking every entrance and exit with a sign.
Yeah, an amendment to that, and then now amendment to that, it's third degree.
I read it wrong. Yes, let me read it again.
No.
thought they had to have in their policy that guns were allowed.
That's what I originally thought too. And so,
I mean, if that's the case, then maybe we have the opposite.
Okay. To the Senator from Harrison.
Yes, sir.
Senator's amendment would be a third-degree amendment. We're on a strike and insert amendment to a bill with a pending amendment to that, and the amendment offered by the Senator from Harrison would be a third-degree amendment, which is outside of our normal procedure. But parliamentarian advises me that if the committee is willing, by unanimous consent or otherwise, to consider a third-degree amendment. So does the gentleman, the senator from Harrison County, ask unanimous consent that he be permitted to offer a third-degree amendment?
I do, Mr. Chairman.
Question, the senator from Harrison County asked unanimous consent of the committee that he be permitted, in this one instance, to offer a third-degree amendment. Is there objection? Chair hears none. Gentlemen, proceed. Wish to discuss further?
No, I think the amendment's clear, Mr. Chairman.
Counselor, you got a sense of what this amendment, how this amendment would change the amendment offered by the senator from Upshur?
I have an idea, but just to be sure, I'd ask you to repeat it, exactly how you would alter the language of the second degree.
Sure, and we can work on it. The essence of it is that the signage requested by the amendment by the senator from Upshur, my amendment would put in addition to it, except where the school is clearly demarked by signage or usage.
Okay.
Marked by signage or usage as a school, or marked by signage or usage that it's...
Let me explain, Mr. Chairman. As I understand the senator from Upshur's amendment, his amendment is that every private school will have a sign saying, you know, concealed weapons not permitted. Because sometimes it's hard to tell what's a school and what's not as a school. I'm accepting out of his amendment, by my amendment, any school that's, you know, St. Francis, St. Francis, I'm trying to think of ones down here, I don't know any down here. Notre Dame up where I live, says Notre Dame, Trinity, those are schools, everybody knows their schools. Seems silly to put people through the process of creating signs for every entrance and exit, and if they miss an exit, or if they have a teacher's exit, there could be an argument that they did not mark that particular exit. I think it's just a cleanup. The senator from Upshur was pointing out to me that he did not believe that private schools could ban, that they have to actively ban concealed weapons, and that certainly leads to another amendment if that's the case, but we'll have to take a look at that here in a second, Mr. Chairman.
Counselor, you got it more or less so that you can write it if the committee adopts it?
Yes.
Okay, question is on the amendment to the amendment to the amendment. Are there members who desire to speak to the third-degree amendment offered by the senator from Harrison County, senator from Upshur?
thank you, Mr. Chair. I appreciate, and on its face, I even initially started to be favorable to the amendment, but I have a problem with it that's sort of twofold. It only answers half the question or half the concern that I have, which is the idea of knowing whether or not you're on school grounds. But private schools have the option of allowing weapons or not allowing weapons, and it's done by a written policy, and that policy would presumably be somewhere inside the building, not readily available to the public. And so it would still subject or allow people to be subjected to what is a felony charge that carries pretty stiff penalties, where on one day you could go to the school and carry your gun legally, and then a policy change overnight flips that circumstance around, and now you're a felon if you go back the next day. And I anticipate, because I've had communication with more than one private school and even have a bill introduced specifically to allow firearms with the permission of the administration at private schools. So private schools are very much interested in having people carry on their campuses. And so I think that merely doing what the senator from Harrison is proposing creates a patchwork, almost like a minefield. One private school may say yes, another private school may say no. Merely knowing that they're schools doesn't tell you whether or not the policy of that particular school in writing would allow you to carry. So I think that it's a friendly attempt at an amendment, but I would not be able to support the amendment because I'm still concerned that we're going to accidentally create felons.
Senator from Rome.
Thank you, Mr. Chairman. Would council, could I ask questions of council?
Absolutely.
I had this question last night, and I recalled. As we debate this amendment and the signage that he's talking about as you come on school property, so I'm assuming it's at the boundaries. Is there any language protecting? Let's say it's a no-gun school, private school, but somebody came in and vandalized and took the signage. Now, are they allowed to carry guns? Will they be in conflict with the law? Are we setting up something? Are there rules that's going to be developed to deal with what-ifs on this bill, the unintended?
If the amendment's adopted and if a vandal has removed the sign and there is no sign in place whenever, a person goes in with a firearm, then there would be no charge.
Even though the school's paperwork.
If the amendment is adopted.
If the amendment is adopted, okay. All right, thank you. Thank you, Mr. Chairman.
Senator from Harrison has a question. Council, gentlemen, proceed.
We were up here having a bit of a debate on the bottom of page 20. You don't need to I'm going to read it to you. It says, "It is unlawful for a person to possess a firearm or other deadly weapon on a school bus as defined in Section 1, I'll skip the articles, or in a public, primary, or secondary education building, structure, facility, grounds, including a vocational education building, structure, facility, grounds, where secondary vocational education programs are conducted, or at a school-sponsored function, or in a private, primary, or secondary education building, structure, facility, where such is not allowed by written policies of the private education institution." So are we saying that we have to, in this bill, we're saying that we're not going to give the same protection to private schools that we do public schools, that they're automatically banned from public schools, but private schools have to take an affirmative step? Why wouldn't we have that reverse, that they have to take an affirmative step to allow concealed weapons in there? Because they ought to have a policy, they ought to have a thought-out procedure for allowing concealed weapons within an educational institution. Or should we change public school and allow them to carry guns on public schools unless they don't have prohibition? Both of them can't be right, can they? They're at opposite. They're both schools, they both have children in them, they both have teachers in them, they have books, janitors, they're exactly the same.
I believe this question regarding, the policy of the schools, any answer would be a policy answer.
Listen, you don't get that cop out this time. Now,
No, you're asking, I think it is a policy question as to whether or not you believe that the private school should, either, one, have the option of disallowing the firearms or having the option of her having to affirmatively disallow it. Currently, under the current law, there's no option for them to allow.
I say leave the option in, but give them the freedom to allow concealed weapons on their premises, not make them have to take the affirmative step and signage all over their school to say that's not our policy. What do you think?
I think that's a
policy reason. I hate this bill. Does anybody else hate this bill as much as I do? Can I see? Listen, they want to throw me back behind the scenes, I'll go to the parent, I'll go to the bar. Tired of being right here, get
Okay. Yeah, it's there under current law. Okay, are there others who desire to speak to the third degree amendment offered by the senator from Harrison County? If not, gentlemen wish to close debate.
Yes, Mr. Chairman, let me be clear that I intend to make an additional amendment to allow private schools the option of allowing guns on their premises, but making the option that they have a policy to allow guns, not that we have to affirmatively make them go have a policy. So I think this amendment's appropriate. I think the senator's amendment from Upshur is appropriate, and even if that amendment, the amendment I just alluded to, passes or fails, his amendment is still appropriate. Because if you can't identify a building as a school building, you need to know so that you can take appropriate steps to determine whether or not they allowed concealed weapons on the premises. At the same time, if a school is I'm getting so confused, the amendment to the amendment to the amendment. We should be able to not have to require schools that are easily identified to be identified. But, may I have a point of order?
Gentleman's stated.
Because the difficulty is that if the amendment doesn't pass to make it an affirmative step for private schools to allow guns on, currently the bill's written so private schools have to take an affirmative step to disallow weapons in their schools. I'm going to suggest an amendment that makes an affirmative step to allow weapons in their schools because we've already banned them from the public schools. We either ought to ban them from all of them or allow them in all of them so everybody can act consistently and people will understand the law. If I withdraw my amendment to the amendment to the amendment, would I then be able to offer an amendment subsequently to the senator from Upshur's amendment?
Great question. It would be the ruling of the chair that if the senator from Upshur's amendment is adopted, it would not preclude further amendments to reform that section of the code. In other words, it's the view of the chair that his amendment is trying to perfect language in it, and generally in reasonable parliamentary order, you try to do that first before you alter or strike the whole thing. So to answer the gentleman's question, such an amendment would not be precluded.
Then let me ask unanimous consent to withdraw my amendment.
Gentleman from Harrison County asks unanimous consent to withdraw his third degree amendment. Is there objection? The chair hears none. Bringing us back to the question of the amendment to the amendment offered by the senator from Upshur County. Are there members who desire to speak further to that amendment to the amendment? If not, I'll put the question. All in favor of the amendment to the amendment offered by the senator from Upshur County, say aye. Aye. Opposed? The ayes appear to have it. The ayes do have it. I declare that amendment adopted. Senator from Harrison County.
This is throwing off my amendment rhythm here, but in section, on page 21, at lines 13 and 14, with the additional language that is added in this bill, and the strike insert begins with, or in or on private, primary, or secondary education building, comma, structure, comma, or facility, unless such is allowed by the written policy of the private education institution. Got it, James? Got it, counsel? So, and if I may speak very briefly.
All right, well, let me see if I've got it. What the senator from Harrison's amendment would do would be to essentially reverse what the current state of that language is, so that the default rule would be a gun on a private school property is prohibited by the law unless they have adopted written policies to permit it. Is that a fair restatement of the gentleman's amendment?
That is, Mr. Chairman.
All right, gentleman may speak to his amendment.
Just briefly, we need consistency. You need to know if you're going into schools that you can carry guns, or if you're going into schools you can't carry guns. Should be the same for public and private. We shouldn't put our private educators at a disadvantage of having to come up with a policy different than the public schools. The bottom line here is, if you're going to allow guns in your schools, I would think you would have to come up with a policy anyways, in order to, see that those guns were properly handled and by whom they were handled, if that is part of the policy. So I think this is a good amendment that will add consistency to this bill should it pass the floor.
Are there others who desire to speak to the amendment offered by the senator from Harrison County? Senator from Upshur.
Thank you, Mr. Chair. Would gentleman yield? I just want to clarify, because I don't necessarily see a problem with the language that's offered in the amendment. The requirement for posting would still be in place in terms of, if it's not posted, then you're not committing the felony in question here, whatever the policy of the school is behind that. Posting is still part of the requirement?
Senator, my intention would be that if this passes, to offer an amendment to the section you just amended, to say that they would post it to indicate that concealed weapons are allowed, and they have a policy allowing concealed weapons. In other words, by making this change, we've made a consistent change to the law that, and on all educational property, public and private, and I forget the exact language, secondary schools, there would be, the policy would be no concealed weapons unless the private school, which would have the complete freedom to adopt a policy to allow concealed weapons.
The concern, although it doesn't apply to this amendment, but anticipating your next amendment, is again that a person may not always recognize that they're on school property. And so...
Your amendment's fine in that regard.
So requiring the posting, I believe you just said you intend in a subsequent amendment to reverse the posting requirement.
No, what I intend to do is to offer the amendment I offered earlier, which was unless it's obviously a school. In other words, by signage or usage, it's obviously a school. I'm concerned about Senator from Maughan's grandchildren who were being shuffled from building to building because they didn't have a permanent location. And I agree with you that those schools need to be clearly demarked as school property and the policy stated.
Okay, well, we'll deal with that amendment when we get to that one, but as it relates to this particular amendment, I don't have an objection to it.
Are there others who desire to speak to the amendment offered by the senator from Harrison? Senator from Wayne.
Thank you, Mr. Chairman. I would have to respectfully disagree because I feel this takes a little bit of the independence away from the private school system. They set themselves apart from the public school system, and the policies that they make are put forth to people that wants their children to go to their schools, by it automatically being declared a gun not allowed. I'm not saying for or against a gun being allowed in school, but I think it's up to the public school or the private school's choice as to whether to make that part of their policy. But thank you, Mr. Chairman.
Thank you. Senator from Harrison?
Senator
from Wayne yield?
Yes,
Wayne yield,
yes,
please.
yes.
Yeah. Senator, you understand that the private schools still have the option to allow concealed
Yes.
weapons on their
Yes.
premises. Do you understand the difficulty in complying with the law that applies one way in some places, the public schools, and a different way
Right.
in private
Yes.
schools? That's
I
what
do.
I'm trying to
I
reach
do.
here is consistency, because it was really pointed out to me by the senator from Upsher's amendment that you will not know how to act depending on what school you're into. Now imagine if you're going to a private school for a basketball game, or a private school parent going to a basketball game at a public school. We're asking people to almost guess, to have to determine before they get out of their car whether or not the school's public or private, and therefore, that's where I think you're going to have difficulties with the law. This amendment simply makes it consistent across the board. If your child goes to a private school that allows concealed weapons, I can think of any number of ways that you would be informed of that, but you're not going to be informed of the difference between public and private schools. And that's my concern. So I think for consistency, the amendment is a good amendment that will help the law to be applied equally and avoid people getting in trouble by carrying a concealed weapon in some place they should not.
Are there others who desire to speak to the amendment offered by the senator from Harrison County? Amendment to the amendment. If not, I'll put the question. All in favor of the senator's amendment, say aye. Aye. Opposed, nay. The ayes appear to have it. The ayes do have it. I declare that amendment adopted. Did you say you have a further amendment? Senator from Harrison.
Given that amendment, Mr. Chairman, with regard to the section that was amended by the gentleman from Upshur, I certainly believe that now everybody will know that unless there's a policy to the contrary, that there is no need, or you will not be able to carry a gun onto an educational institution's property. So I believe that requires additional amendment to the senator from Upshur's amendment. And I'm not sure what it says, so I'm going to guess, but essentially what I would like to say is that if there is a policy permitting concealed weapons, that ought to be the signage that the senator from Upshur was referring to in his amendment. In other words, we can apply consistently now. No concealed weapons on any public or private secondary educational institution. So now the signage would have to be that you can carry a concealed weapon on the premises.
All right. Counselor, you got it?
No. My understanding of the previous amendment is that would have negated the senator from Upshur's amendment. What I currently have, my understanding of what that amendment was, is it's unlawful for any person to possess a firearm or other deadly weapon on yada yada, or in or on a private primary or secondary education building, structure, or facility. And then the way I thought this would best be written is provided that it shall not be unlawful to possess a firearm or other deadly weapon on or in a private primary or secondary education building, structure, or facility when such institution has adopted written policies allowing for possession of firearms on or in the institution's building, structures, or facilities.
I think that's perfect. We're talking about the senator from Upshur's amendment.
Well, no, I agree with counsel. The chair's interpretation was that the amendment by the senator from Harrison, the committee adopted, negated the amendment by the senator from Upshur. But as I understand now, you're offering to add an amendment to add language that says when such policy has been adopted by primary school and the facilities have been posted, that guns are permitted by policy.
That was my intent.
Okay, that's how I took it.
How would you know that the school has a policy regarding concealed weapons if there was not a sign?
Okay. Questions on the amendment offered by the senator from Harrison, senator from Upshur County?
Thank you, Mr. Chairman. I would actually like maybe a little bit of clarification. I didn't understand the previous amendment to have wiped the slate on mine, and I just kind of wondered if there's a proper way to do that to get a sense of the committee. Is that what everybody else understood? I thought we were merely changing the one sentence, not... Well, you didn't say that. So if I'm the only one, then...
I don't think it's the case, does it?
I don't even think the senator from Harrison thought so. And he's the one who offered the amendment. No, he's not trying to bring mine back. He's trying to bring back something similar to mine, but in reverse.
I think the state of the bill is, at the moment, is exactly as council just explained it.
Okay, so I just want to make sure that everybody does know where we are. And then
And I believe that the Senator from Harrison's current amendment, the pending question is whether to add a requirement of posting a notice for schools for private schools which have adopted written policies that would permit firearms on the premises. And I thought the Senator from Harrison concurred that that was his motion.
Yeah, Mr. Chairman. But let me say, and I would be glad to state that amendment giving the private schools the option of posting signage. But if we've now said that you can't carry a gun on any public or private school property unless the private school has a policy permitting such, and Senator, I was thinking of your amendment, I think you would want to have signage or give the private school the option of having signage saying, we have a policy permitting concealed weapons on our property, so that they would be able to carry if they wanted to.
the issue that I'd have with the signage is that I believe the signage, we have a presumption in the state of West Virginia if you have a concealed carry permit, and that presumption will extend into what we're creating here if we go with a permitless or constitutional carry, that you can generally carry anywhere in the state of West Virginia unless you're expressly prohibited from carrying there. So this turns that on its head and makes the assumption that you won't be allowed to carry in an area where you may or may not understand.
If I may, and I'm not weighing in on but gentlemen, the senators will remember, we're dealing with a section that relates to schools. So we're not talking about concealed carry, we're talking about possession. It's a felony to carry a gun onto school under current law.
Right.
Public or private, that's our law right now, isn't it, Counselor?
Yes, I rose to point out that fact that it's currently prohibited.
So we're not talking about concealed carry or anything else. We're talking about having a firearm on school property is a felony, period. Current law is public or private school. What the committee has worked forward to on this is preservation of all that, except authorizing a private school to permit firearms, if they choose to, by written policy within their school facilities. So now, where we are, I believe, is the Senator from Harrison's pending question. The motion is to require posting a notice of that.
And again, so...
Optional notice, Mr. Chairman.
Optional notice. Okay.
An optional notice that guns are allowed on that particular campus.
Well, if the Senator from Harrison would yield.
Yes.
If the law is going to permit private schools to decide that they want to allow a firearm within their facilities, why do we need to say they have the option of posting that? In other words, they clearly have the option of posting that if they choose to.
I didn't want to make it mandatory that they do post. They may want to advise all parents and teachers they can carry concealed weapons and not be interested in advising the general public. I thought it gave them more freedom of choice. I will be glad to withdraw.
But I think they have that freedom of choice without codifying it, don't they?
But if they, that's fine, Mr. Chairman.
The gentleman from Harrison County asks unanimous consent to withdraw his amendment. Is there objection? Chair hears none. Okay, are there further amendments to the strike and insert amendment? Senator from Upshur.
I guess a point of order, would it be appropriate for me to offer the amendment that I previously offered to be added to the section that we just completed work on? So it would go after private educational institution, or as counsel explained it. Again, not realizing that we were wiping my signage requirement, I still want the signage requirement in there.
Well, the gentleman may proceed with an amendment. Senator, state his amendment.
There is no signage requirement still in here because now it's, the affirmative action of the private institution to make it permissible to carry firearms. Now, it is still, you still have the option of, it's not in code, but they could still, put up the sign saying we permit firearms, but as it's written currently, that's not mandatory. So, I mean, would your amendment make it mandatory that they put up a sign?
My prior amendment that was adopted made it mandatory that you had to put a sign up that said weapons are not allowed. And so, again, and I don't think the senator from Harrison understood either, because he just reiterated again that my signage requirement was still in there, but it's not still in there.
Well, if I may, your amendment was, that my understanding was, maybe I'm confused, was that it's unlawful if they've adopted the signs and clearly posted it. Now, my understanding of the subsequent amendment that was adopted is that it is only unlawful, I mean, it is unlawful unless the institution adopts the signs, adopts the policies to prohibit the firearms, so you couldn't say, that those don't go together, saying you have to have the sign if you're making it unlawful, but yet it's going to be unlawful unless you adopt a written policy. That's why my understanding was that the subsequent amendment negated the Senator from Upsher's amendment. So I think I've talked myself into a circle now.
Counselor, I'm not sure, I think I understand what the Senator from Upsher's trying to get, but he could, or someone could, craft an amendment that said for a private school that has not adopted a policy to allow weapons on its facilities is then required to post or put up signs to make clear that weapons are not permitted. Is that what
It is, because the amendment offered by the senator from Harrison only answered half the question, which is if you know it's a school. If you don't know it's a school, or if the policy changes from one day to the next, you may not be aware of a policy change, you may not be aware that you're on a school campus, and we're not talking about a light-duty fine, we're talking about a felony that involves jail time. So you accidentally stumble into a situation through no ill intent that leaves you a felon, and so that concerns me greatly. And so the posting requirement was to simply negate that possibility to the great. If you carried a gun on such a campus, you would know it. Now we won't know.
is that the gentleman's amendment?
The entire thing, yes.
You got it, Counselor?
Yeah, my understanding is basically adding a requirement to the code that any private school must have posted that they do not allow possession of firearms on their school grounds.
If they do not.
Which they all do not automatically, they would have to adopt the policy allowing it.
Senator from Upshur, is that it?
That's it.
All right. Are those who desire to speak to the amendment offered by the Senator from Upshur? Senator from Harrison?
I know we're getting confused, and I apologize. But if every school, private or public, does not allow handguns unless there's affirmative policy, I think the senator's amendment only needs to address situations where they have a policy permitting guns or are not clearly marked as a school. And as in the case of the senator from Mon's grandchildren. Otherwise, St. Francis High School, you don't have to ask any questions. If there's not a sign saying you can carry guns, you can't carry them. That way the law is consistent across the entire state. And I would offer an amendment to the amendment if it wasn't the fact that it would confuse everybody to death. I would just speak against the amendment and suggest that I will offer an amendment, should it be defeated, that would embody what I just said, that only schools that permit guns or are not clearly demarked as a private school would need to have signage. Otherwise, we're going to have signs in every school in West Virginia that's a private school. I will offer that amendment should the senator from Upsher's amendment be defeated.
Are there others who desire to speak to the amendment pending before the committee offered by the senator from Upshur County? If not, Senator from Upshur wishes to close debate on his motion. Senator from Upshur County.
Thank you, Mr. I would just point out that we already have this within our code, as I understand it, that any private business that doesn't want to allow firearms has an affirmative requirement that they post a sign saying you're not allowed to bring a firearm into this private business. And while obviously a private school is a little bit of a different scenario than going to a convenience store or something along those lines, it is a private business still. A private school is a private business. Some are for profit, some are not for profit. But this essentially leaves them in the same category that they have an affirmative duty to let people know that you can't carry a gun here. And so I would ask for adoption of the amendment.
Question is on the amendment offered by the senator from Upshur County. All in favor of the amendment, say aye. Aye. Opposed, no? No. Noes appear to have it. Noes do have it. I declare the amendment rejected. Are there further amendments to the strike and insert amendment? Senator from Jefferson County.
Thank you, Mr. President. I have an amendment.
Thank you for the promotion.
I have an amendment on the size of the signs. No, just a little levity, but I do have a serious amendment, but I thought we'd beat the signage around for a while. Mine is a substantive amendment regarding duty to inform a law enforcement officer, and the failure to do that, to inform a law enforcement officer, is up to $1,000, it's a misdemeanor, up to $1,000 fine, and up to 1 year in jail for failure to inform an officer that you have a weapon.
Where does the senator from Jefferson propose that goes within the
I would
strike
say
and
it's
insert amendment?
between the consultation of our counsel and the chair will find the proper place.
And let me ask, just so we know exactly the scope and breadth of the senator's amendment, does that apply to people who are carrying with or without a permit, both?
It would be with carrying without a concealed weapons permit. I don't want to add that on to, currently there's not such a duty to inform if you have a concealed carry. So this would be if you do not have a permit issued as you have today and you're carrying without a permit, you have the affirmative duty to tell a police officer when approached for questioning or whatever that you do have a weapon.
So under the senator's amendment, the requirement would exist only for people who are carrying concealed and without a permit.
Yes.
It would not apply to the provisional permits or the regular permits that are, we're calling permits, but actually
would not.
licenses under the bill.
It would not, if one wants to amend that my amendment is only for the permitless carry.
Counselor, you got it? You think if committee adopts this, to be able to craft it, find the right place for it within the strike and insert amendment?
I believe would need some further clarification, specification as to the situation in which the duty would arise.
Okay,
Senator from Jefferson.
I would be open to, it seems like a fairly straightforward amendment. Some other states have that, and I would say if you look at some of the other states that have adopted this amendment, the exact trigger where that arises, but...
I've looked at other states
Okay.
and they vary, so.
Can you suggest from a collage of those what language would fit? What's the trigger when approached by a police officer? When physically approached and...
Maybe when detained under reasonable suspicion of criminal activity. That's the...
Well, that seems like a pretty high bar. In other words...
Well, no, I mean, that's the, I believe that's the Terry frisk standard. What gives the level that rises for an officer to be able to stop you and pat you down.
Right, that's exactly
And that's
what I want.
reasonable suspicion.
Reasonable, that's fine. In other words, if you're stopped for whatever traffic violation or whatever, and you have a gun, that you have a duty to inform the officer that you have a gun. And that's only if you do not have a permit, because today I don't want to lay in another layer on those that rightfully have permits and have obtained them today. So this only applies to the new section where you don't have a permit. You're exercising your rights, but you would have the duty to inform.
I understand the amendment. I am compelled, this is something I've researched. I am concerned about such a provision when coupled with the enhanced penalties or now the additional crimes that are in this bill for Fifth Amendment self-incrimination concerns, and I have not been able to do, a significant amount of research on it. However, making it a misdemeanor, requiring a duty to inform, but at the same time, providing for criminal acts for possession of the firearm, if you are, currently committing another felony or, a prohibited person, you're basically making it a crime for someone not to tell you that they're committing another crime. I have not done this significant amount of research that that I could point to say that is 100% an issue, but it's a concern that I would feel
Well,
compelled to.
again, I don't want to make this, it's not nearly as complicated as a sign amendment to understand. But at the same time, what I'm attempting to do is capture what is embodied in a few other states, that you must tell a police officer when approached that you have a weapon. It's common sense. And if you fail to do that, these are not felony offenses. It's up to $1,000 and up to a year in jail if you don't. So I don't think it's complicated. And that's my amendment, Mr. Chairman.
Okay. Counselor, you do understand his amendment, apart from the, question you raised, but
Yes.
to be able to craft it and insert it if it's adopted. Okay. Who desires to speak to the amendment offered by the Senator from Jefferson County, Senator from Taylor?
Thank you, Mr. Chairman. Will the gentleman yield? So your amendment suggests then that if someone is carrying a concealed weapon, if this bill passes, legally carrying a concealed weapon in the console of their vehicle, and they're stopped for a speeding violation, that they would be required to advise the officer that they have a concealed weapon in the vehicle, even though there's no, in my understanding, there's no way that the law enforcement officer would be able to search the car to find that vehicle or anything like that. You just have to, you're required to tell them that you have it. Is that what you're proposing?
If we could ask counsel, are you familiar, counsel, with the other state triggers? Is it on your person or in the vehicle?
Again, they vary, but my understanding of your amendment is that the duty to, once you're detained, a traffic stop is a detainment upon reasonable suspicion that you're, currently violating. There's further to actually search the car, there's further reasonable suspicion needs to arise.
And so there's no way a police officer would ever be able to discover that?
Well, unless
there was some other reason that he gained
knowledge
probable cause to do a search of the vehicle.
Right.
But for a normal law-abiding citizen that would be stopped for a traffic stop, have a concealed weapon in the console of his vehicle, he would be required to notify the police officer under this amendment.
The amendment is vague to the point to where I don't know if I could definitively answer that question, because again, we're referring to the other states, they vary significantly.
Well, I'm sorry, if in fact this amendment would pass and they were required to notify the police officer, does then that give the police officer probable cause to search the car?
If he had reasonable suspicion that there was a firearm in the car and the driver did not inform him that they were in possession of the firearm.
But if the driver did inform him that there was a firearm there, would that give the officer probable cause to search the car, or would it give the officer probable cause to ask the person to step out of the car and perhaps be searched and be treated substantially differently than someone who was stopped for a speeding violation who would just receive a citation or a warning and drive on?
Theoretically, I mean, what is reasonable suspicion and probable cause is that's going to vary depending on each situation, and it's subjective to the officer. It's not difficult for an officer to articulate that they have the reasonable suspicion to do a search in the vehicle
Okay,
irregardless, so.
I'm going to interject here, because the Senator from Taylor's question is a good one, and really, it's, I think, the burden is upon the Senator from Jefferson to clarify his amendment and tell us what he wants the scope and breadth of it to be. Does it apply in the situation the analogy the Senator from Taylor put to council, the question, a motor vehicle stop with a weapon in a glove box?
Well, counsel, if, again, you've done the research in the other states, could I perfect my proposed amendment so that it's on your person or within immediate arm's length reach? I mostly meant if you're stopped on the street and you have a gun, could you help me perfect that, counsel? That I'm not trying to get at the glove box. I'm trying to get at the guys that are on a street corner or whatever.
A glove box is considered immediate reach in a vehicle, under case law.
Pardon me?
Under case law, a glove box is immediate reach.
So the Senator from Jefferson's amendment is a duty to disclose for non-permit holder, non-license holders, non-provisional license holders, carrying a gun or having one within arm's length reach.
Yes.
And a misdemeanor
On their person or within arm's length reach.
and making it a misdemeanor for failure for a person to do that.
Right.
All right.
And I'd like to close on the office.
Certainly. Senator from Wayne, wish to speak to the amendment?
Thank you, Mr. Chairman. I would have to respectfully disagree with the amendment, in addition to the reasons that council made, but also some accidental misdemeanors that will be out there because, if you just, when you get pulled over, detained, you're not always going to have that in the back of your mind to make sure you tell them it could have been in your console for the last year and you never used it, or, I just think it would cause undue hardship on many people. Thank you, Mr. Chairman.
Others who desire to speak the amendment offered by the Senator from Jefferson. Senator from Upshur.
Thank you, Mr. Chair. I would speak against the amendment. The Fifth Amendment concerns, I think, are very real. I had some discussion with law enforcement as some elements of this bill were being discussed and potential things, and even the law enforcement folks that I spoke to agreed that if you're going to hit somebody with a misdemeanor for a failure to inform, you may well be endangering a real crime, a felony, assault, etc. Because a person who fails in their duty to inform,
Sometimes it won't come on either.
A person who fails in their duty to inform would be essentially failing to incriminate themselves. So you could very easily lose some very important criminal cases because of an amendment like this in this bill. And I don't think we want to, the entire purpose of this is not to make it so that we catch up the innocent person who forgets at some point in this process exactly where the duty to inform would arise. Instead, we want to make sure that we're catching criminals and allowing law-abiding citizens to exercise their rights. And I think this amendment would sort of reverse that effect. We would see a lot of innocent people caught up in it, and we probably would see real criminals let go because of that violation of the Fifth Amendment.
Senator from the 2nd.
Thank you, Mr. Chairman. I'm going to speak against this amendment as well for the same reasons that the Senator from Wayne and the Senator from Upshur both stated. I mean, we've gone and we've heard at great length testimony of young women that want to be able to defend their families, defend themselves. This amendment, as we've seen from the confusion of the questions, is that in arm's length within the glove compartment of when I used to have a Fiat, or is it arm's length in the glove compartment of my pickup truck? I mean, there's so many variables, so much confusion that can be caused by this amendment. We're actually going to discourage people from exercising their Second Amendment rights and defending themselves. We're opening ourselves up to a whole bunch more legal opposition, legal arguments. I just think this amendment really just takes away from the intent of the bill as suggested by the senator from Upshur. I speak against this amendment.
Senator from Rome,
Mr. Chairman, can I ask counsel a question?
proceed.
Counsel, what's the duty to inform now if you have a gun in your car, whether you're a permit holder or not?
There is
And an
no,
officer comes up, there's none?
no.
So this would be new language and possibly protecting the officer by asking that question. Is that correct?
I didn't get the last part. It would be new language. It would, at current law,
Well,
there is no
officers
duty to
asking for
inform.
their own protection. Or excuse me, the officer's not asking, but your duty to inform would be at the officer's protection. Is that correct? If you don't tell them, I mean, the officer, when you go over to undo your glove box to get your registration card and a gun is exposed, in my mind, I'm thinking an officer may be pulling his gun at that point. I don't know. I'm just trying to think, would this protect or would this not? The officer.
I mean, I think ultimately that'd be, I mean, difficult to whether or not, because, well, I think actually ultimately, you know, I think it's reasonable that any individual with a firearm who intends to do harm to the officer is not going to worry about the misdemeanor.
Right, I agree
So
with that statement, but my
it's-
thoughts are the innocent people who reach over to grab, to get their registration, and the officer sees a gun being exposed. They have not told the officer that there is a gun in the glove box. Now, will this person be in a situation that the officer may have a gun pointed at them because he doesn't know if they're going to get the gun, or, and I'm just trying to think, what will help?
Yeah, I mean, I can only say if I was a police officer and I did not know that there was a gun, all of a sudden I see a gun inside the car,
You'd
I'm
probably
gonna,
be
I'm gonna
reacting.
draw my weapon, but, and I don't know this, it's probably dangerous, but I would assume that they're trained as, if they see a firearm to, you know,
their
draw their
weapon.
weapon, but, ultimately, I'm not sure if I've answered your question though.
Yeah, you haven't, yeah, I didn't know if there's a duty now to inform if you had a
No.
gun. This would, okay, thank you, Counselor. Thank you, Mr. Chairman.
Thank you. Or Senator from Harrison County wishes to speak to the amendment?
Yes, thank you. Thank you, Mr. Chairman. Senator from Rome, I think, hits the nail on the head here. In advising a police officer you have a weapon, you avoid a tragedy that didn't have to happen. When an officer sees a gun, he's going to react by pulling his gun. You're going to be face down the barrel of a gun. You make a nervous, wrong move, you're going to likely get shot, and rightfully so, because the police officer has the right to protect himself. Every time I've gotten pulled over in the last 15 or 20 years that I've had a concealed weapon permit, the first word out of my mouth is, "Officer, I have a concealed weapon." If it's on me, I do it quicker than if it's in my glove compartment, because I want them to know that I have a weapon. I'm not going to make any moves towards that weapon. That's common sense. 4 of the other 6 states, and maybe the 5th one, I haven't looked at Arkansas, but 4 of the other 6 states requires the very amendment that the senator is making. Because when you're in those situations, when an officer is there worried about his life, because everybody is going to, be able to carry a gun, common sense dictates that you identify, and if you're a law-abiding citizen, you should have no problem, "Sir, I have a concealed weapon." Now, if it's lawful, does not give them probable cause to do any further search of your vehicle without some other fact being in place that would allow them to search your vehicle. And it reminds me of the joke my chairman told me about the little old lady who got pulled over and she had a gun on her seat and her glove compartment, her purse, and it was a very good joke, but it's the same situation.
Chairman
You want-
stole that joke.
Yeah, that was a good joke. If you're out to hurt the officer, you're not going to tell him, and that's very true. But if you are a law-abiding citizen, have a concealed weapon, you advise the officer, calms the situation down, he can act accordingly, there won't be any surprises that could get somebody unnecessarily killed. I speak in favor of the amendment if you couldn't figure that out.
Are there others who desire to speak to the gentleman, the Senator from Jefferson's amendment before I recognize the Senator from Jefferson to close debate Senator from Jefferson.
Thank you, Mr. Chairman. Again, this is just a real common sense amendment, and as I've been contacted, we've all been contacted by a lot of people on this, but without exception, the law enforcement community, the Sheriff's Association realizes that this bill is probably going to pass. This is the one, with losing the fees and so forth, this is the one single item repeated over and over and over by the contacts from law enforcement that I've had, that law enforcement would like to have in the bill. And that's why it's here today. I would just ask it to support the amendment. If it needs further refinement, instead of prolonging it here, we could come back tomorrow and have this refined amendment, but there's still time when it goes to the floor. If this needs to be further refined, the chairman and I can work together to refine it if there's tweaking. But again, we're changing a House bill. This is very likely going to go to conference committee. But if we do not embed this common sense amendment idea into the bill, I think it will never be in there. So this is our opportunity to embed what the law enforcement community has asked for. I think it is a very important amendment, and I ask for your support.
Question before the committee is the motion to amend the strike and insert amendment offered by the senator from Jefferson. All in favor of the motion, say aye. Aye. Opposed, no? No. Noes appear to have it. Noes do have it. I declare the amendment to the amendment rejected. Are there further amendments to the strike and insert amendment? Senator from Harrison County.
Thank you. And I didn't come up with this myself. I'm looking at, of course, 4 out of 5 states, and I was just informed Arkansas did not pass permitless concealed carry, so there's only 5 states. And this didn't work the last time because 4 or 5 of the other states required you to inform police officers. I may lose again. But this is common sense. You know, I worked in bars going through college, so I helped put myself through school. Alcohol and guns do not mix. And I'm looking at my chart here, and 4 of the other 5 states do not allow you to carry a concealed weapon if into an establishment that sells alcohol, and I would make that amendment. I don't think we need a crowded room of people consuming alcohol and having concealed weapons in their possession. I think it's a opportunity, a bad opportunity. They don't mix well, and I think we could avoid tragedy by keeping them out there. I understand the guys who are going to violate the law are still going to carry them in, but I think you're talking about people that become intoxicated. You know how many fights, I mean, that's where I'm coming from, that we would see fights every single night, and I think having a weapon interjected into that atmosphere is a mistake.
Let me ask a question of the senator from Harrison, if I may, just so we can help counsel and frame the question, the amendment, and have the committee know what it's voting on. Does the gentleman's prohibition apply to permitless and licensed carry?
I was not going to make that distinction. I think it applies in this article for permitless carry, but I would think it would apply both to permitted and non-permitted weapons. So let me state the...
Let me ask a further question.
Yes, sir.
Does the gentleman's amendment apply to open carry?
I don't know that we can curtail open carry. I certainly think if you carry an open weapon into an establishment, the owner has the ability to ask you to leave or remove your weapon, place your weapon in your vehicle. So I would not say that it would apply to open carry.
Not to open carry, but it would be a prohibition on carrying a concealed weapon,
Yes.
with or without a license or provisional license, into a Class A.
Well, Mr. Chairman, would you mind if I stated the amendment? I have it here in front of me. It has
Please
a
do.
couple of exceptions. The person carrying concealed does not carry the weapon in any place where liquor is sold for on-site consumption, except a restaurant, and then only if the person does not consume alcohol. That is the Alaska exception. The same exception exists in Arizona, and the same exists in Maine. I'm trying to look here very quickly, and the same exists in Wyoming.
Okay. I think, Counselor, you got it?
Would the prohibition apply to just firearms or all concealed deadly weapons?
I think it should apply to all concealed deadly weapons.
Well,
but
it's your
we're just
amendment.
talking about firearms.
It's your amendment, so you
Yeah,
get to
well,
write it
I'm
however
gonna-
you
I'm gonna
want,
limit it
and then
to-
we vote on it.
I'm going to limit it to this article,
But this article covers,
then I would
Concealed deadly weapons.
term it a concealed weapon.
Okay. Are there members who desire to speak to the amendment offered by the Senator from Harrison? Senator from Upshur.
Thank you, Mr. Chair. First, a question for council. What's the current status of the law if you have a concealed carry permit related to this issue?
I mean, there's no
Prohibition at all?
prohibition against any, like, carrying where alcohol is sold.
Are you aware of any particular examples where people with a concealed carry permit have wreaked havoc inside of a bar or other drinking establishment?
Well, probably a couple of news reports, just
I
general.
mean, some actual reports of concealed carry holders doing this, or?
I don't know if they would have, I mean, just one recently comes to mind, but I couldn't tell you if they had a concealed weapons permit or not.
And so if they didn't have a concealed weapons permit, they were committing a crime just to have the gun concealed.
Theoretically, if they did not.
If they didn't have, I don't have a great awareness myself of, bars and so on having big shoot-ups like Wild West. I know we sort of draw that picture, but I haven't heard of it. And we currently don't bar people from bringing weapons into these establishments. So I would speak against the amendment just on the basis that it doesn't seem necessary.
Senator from Kanawha County.
Thank you, Mr. Chairman. We keep hearing common sense. To me, this is anything but common sense. I'm opposed to this motion. It makes no sense to me. I keep reiterating, we have open carry now, we have permitted carry now. All of these rules and amendments that are being offered are not common sense. They're anything I hear about Arkansas, I hear about other states. We ought to be concerned about West Virginia. I oppose the motion.
Senator from Taylor.
Thank you, Mr. Chairman. Will the senator from Harrison yield? Your amendment, you mentioned liquor. Do you intend to include wine and beer?
Yeah, it would be wherever alcohol is sold for on-site consumption.
Well, in your restatement of the amendment, you said where liquor is sold. So I want to make sure.
Let me look again at the Alaska amendment, which
One time you said where alcohol is sold.
it does
one time you said where
say liquor. Their amendment was limited to liquor.
So what's your amendment?
That was my amendment.
Your amendment is just limited to liquor. So
Yes.
if a wine bar or a beer joint or other places where beer is sold, it's okay?
I thank you for pointing that out. I would ask unanimous consent to revise my amendment to be where alcohol is sold. I don't care if you're drunk on alcohol, wine, whiskey, or tequila, it's the same threat.
Thank you, Mr. Chairman. Just wanted clarification.
Thank you. The Senator from Harrison County asks unanimous consent to reform his amendment to extend the prohibition to places selling distilled or fermented beverages.
Alcohol would be fine, sir, but that's fine, however you want to state that.
All right. Others who desire to speak upon the motion to amend by Senator from Harrison County before I recognize him to close debate upon his motion to amend. Senator from Harrison County.
When somebody says I don't have common sense, it really surprises me, because I think I have really good common sense. If I'm sitting in a bar with my wife, a crowded bar, let me rephrase that. If the senator from Kanawha is sitting in a bar with his wife, a crowded bar, and somebody pulls a gun, you don't want me pulling my gun and trying to shoot in a crowded bar. Common sense is the exact opposite in this situation where alcohol is involved and where people's tempers tend to run off and their judgment tends to wane from that consumption. Doesn't mean you can't keep your concealed weapon in your vehicle. Doesn't mean you can't protect yourself, but I think that the mix, whether they're law-abiding or not, when they're intoxicated, think of drunk driving. Think of the greatest factor in spousal abuse. It's always alcohol. We don't have good judgment. It's not a place where we want to have weapons in West Virginia. And I point out that the other 4 states that have adopted this exception certainly had common sense legislators at their bar. Thank you.
Question before the committee is the motion to amend offered by the senator from Harrison County. All in favor of the motion, say aye. Aye. Opposed, no? No. Noes appear to have it. The noes do have it. I declare the amendment rejected. Are there further amendments to the strike and insert amendment? Further discussion? Senator from Ohio County. Excuse me. Senator from Greenbrier County.
Thank you, Mr. Chairman. Could I ask one more question of our council? One more question, Council. James, I'm sorry to keep making you jump up and down. I just have one question. I was trying to find it on the computer when I kicked on something a little bit ago, and I don't know, it was a discussion, I think. I'm concerned about reciprocity, and I know the NRA say this, the permitless carry does not affect that, but we're one of the few states that survived with Virginia before they kicked it back in. I'm very concerned about this with this legislation.
As far as reciprocity goes, my understanding is that our current agreements are protected under the way that this is structured by leaving the permit process procedures in place, and then during the 18 to 21, the provisional permit process. Under the provisional permit, anyone with that would not have reciprocity with, all of our other states that we have reciprocity with. I believe that there's maybe 4 or so states that have the equivalent of 18 to 21 permits, and we would perhaps have reciprocity with those states with the provisional permits. And then with our permitless carry, anyone that doesn't go get either of the permits will have no reciprocity or any acknowledgement of rights amongst any other states.
So,
except for the ones that have, the
right.
5 that have permits.
So if I were going from here to Florida and I do not have my permit because I don't have a permit, I'm in violation of law in every state I go through then?
Yes.
And I don't think any of them have permitless carry. So it's only only within our state then that this would be.
Yes.
All right. Thank you.
Question before the committee is the motion by the vice chair, the senator from Ohio, to adopt the strike and insert amendment as it's been amended by this committee. Is there discussion upon the motion? If not, all in favor of the motion say aye. Aye. Opposed, no. No. The ayes appear to have it. The ayes do have it. I declare the motion adopted. Senator from Ohio County.
Thank you, Mr. Chairman. I move that we report House Bill 4145 as amended to the full Senate with the recommendation that it do pass.
The motion by the senator from Ohio County is that committee report House Bill 4145 as amended to the full Senate with a recommendation that it do pass. Is there discussion upon the gentleman's motion? If not, all in favor of the motion say aye. Aye. Opposed? No. The ayes appear to have it. The ayes do have it. I declare the motion adopted and the bill will be reported to the floor.